Good morning, Your Honor. Edward Drugas on behalf of Ashley Pix.
Ashley Pix.
All right.
What we're about to witness is a courtroom moment that perfectly shows the difference between what a defendant asks for and what the court actually trusts them to do. This case centers around Ashley Pix, who is standing before Judge Simpson hoping for probation instead of jail time. On the surface, that might sound like a simple request. After all, probation is often granted when someone shows responsibility and cooperation with the court. But here's the twist. The court record tells a very different story. According to the documents the judge has in front of him, this isn't Ashley's first opportunity to cooperate with the court system. In fact, the timeline shows multiple missed court appearances, repeated failures to follow instructions, and several bench warrants just to get her back into the courtroom. And that's a huge red flag for any judge deciding whether probation is appropriate. Because here's the reality. Probation is built entirely on trust. When someone is placed on probation, the court is essentially saying, "We believe you'll follow the rules outside of jail." But when a defendant repeatedly fails to show up for hearings or ignores court instructions, that trust begins to collapse. So the real question hanging in the air right now is simple. Will Judge Simpson believe that Ashley is ready to change? Or will the court decide that probation is simply too risky in this situation? As this hearing unfolds, pay close attention to how the judge reviews the timeline of missed appearances and broken promises. Those details are going to become absolutely critical to the final decision.
Your Honor, we've gone through the pre-sentence report. The recommendation is something my client wants to address today. The only correction I have to the face of the pre-sentence report is the attorney should be listed as myself rather than public.
Okay. Ma'am, anything you want to tell the court before I'm sentenced?
I was wondering if I could be placed on probation. Since
You want to be placed on probation?
yeah, since I did a month in the Wayne County last month. I'd rather be on probation than incarcerated.
Your Honor, Teresa Clare on behalf of probation.
Yes.
Ms. Pix was ordered to probation to complete the pre-sentence interview. It took some effort to get that done initially because it was done quite some time ago, and then Ms. Pix has numerous times failed to appear to this court for sentencing.
This statement from probation is incredibly important because it introduces the biggest issue in Ashley's case: failure to appear. In the legal system, missing a scheduled court date is not a small mistake. It's a serious violation of the court's authority. Every time a defendant fails to appear, the court often has to issue something called a bench warrant. That means law enforcement is authorized to arrest the individual and bring them back before the judge. And the more times this happens, the worse it looks for the defendant. Probation officers play a key role in sentencing hearings because they are responsible for monitoring whether someone actually follows the conditions of probation. When probation says they have concerns, judges take that very seriously. What the officer is basically saying here is that Ashley has made promises before. Promises to attend interviews, promises to show up to court. But those promises were never followed through. That pattern creates a credibility problem. And here's the legal reality. Probation is not meant for people who repeatedly ignore court requirements. It's designed for individuals who show they're willing to cooperate and comply with the system.
While she has been out on bench warrant status, she's also picked up other cases, one being an OWI out of the 15th District Court, which is holding her in custody. Not to mention, it was brought to my attention, she now has a couple other cases out of
Romulus,
which are bench warranted now because she has failed to appear, I believe, because she was not here.
it was a show cause. I don't think a warrant issue.
I went to court.
Oh, a show cause.
Yeah.
So she is, Your Honor, scheduled
Oh,
for show cause matters because she failed to appear, because she was in custody here for those Romulus cases. Probation's concern with Ms. Pix is that she does come before this court and indicates that she wants to do things, but she never follows through with any of it. So probation has concerns that if Ms. Pix were to be released on this case, she's not going to do it, and she's not going to contact probation. I know that and this court knows how I operate. I attempted to reach Ms. Pix multiple times to try to even get her to get in here to get sentenced, because originally I believe my recommendation was to have a probationary sentence. However, it's getting her here, and if she doesn't come to court, she's not going to report to probation.
Well, and the cold hard reality is that May and June she didn't appear, but she just, the simplest of things to complete your pre-sentence interview, she didn't do. Had to issue a bench warrant in her cases, in this case, 4 times.
This moment right here is where the tone of the hearing completely shifts. The judge is no longer just reviewing paperwork. He's laying out the entire pattern of behavior that led to this point. When Judge Simpson starts counting the number of bench warrants issued, 1, 2, 3, 4, that's not accidental. Judges often do this to highlight just how many chances a defendant has already been given. Each missed appearance requires court staff, law enforcement, and judicial resources to track the person down again. It wastes time, costs money, and disrupts the justice process. So by the time a case reaches this point, the judge is usually asking one key question: how many chances are enough? You can also hear the judge focusing on something very specific. Ashley didn't even complete the pre-sentence interview at first. That interview is one of the simplest steps in the sentencing process. It helps the court gather background information about the defendant, including employment, housing, and personal history. When someone can't even complete that basic requirement, it signals a deeper issue with compliance.
Before we can get you here.
I promise I'll do it.
You're not a good candidate for probation. I mean, I couldn't even get you to interview with probation initially. You didn't even follow the court's instruction to do that. And then had the bench warrant you didn't appear, had to basically make it an in-person hearing, which I don't specifically recall why, but that typically means there's an issue going on with getting the person there. So, and I'm not sure, in January of this year, you were brought into custody somehow. So even after I'd issued 2 bench warrants, one that I recalled, you did that. And on the recommendation initially on April 24th, 2024 was for a probationary sentence, but that was in April of 2024. You didn't appear. I issued a bench warrant, and then we don't see you until January. The magistrate, I'm not sure why, but granted you a PR in January, on January 16th. On January 29th, you were supposed to appear before me, and you didn't show up. You came back again into custody for whatever reason in June, and the magistrate, I don't know why, gave you a PR because you said you'd appear. And that was in 2025. And on the date he gave you didn't appear. That's where we are. You don't do what you say you're going to do. And the reality is, when I've seen these in the past, what will actually end up happening is we put you on probation, and then ultimately I'm imposing the jail time because you haven't done anything.
This is one of the most revealing statements in the entire hearing because the judge is speaking from experience. Judges see thousands of cases over their careers, and they start recognizing patterns. What Judge Simpson is describing here is a cycle that courts encounter all the time. A defendant asks for probation. The court gives them the benefit of the doubt, but then the defendant fails to report, misses appointments, or violates the terms of probation, and eventually ends up in jail anyway. From the judge's perspective, that process wastes time and delays accountability. So what he's essentially saying here is, if the evidence already suggests that probation won't work, the court may skip that step entirely and impose jail time now. This isn't just about punishment. It's about efficiency and credibility in the justice system. And here's something interesting to think about. Sometimes defendants believe probation is automatically the lighter option. but probation actually requires strict compliance, meetings, programs, reporting requirements, and often drug or alcohol testing. If someone already has a history of ignoring court instructions, probation can actually set them up for failure. So when the judge says he's seen this situation many times before, he's signaling that he's not convinced probation would change the outcome here.
Anything else?
Can I be placed on the tether? GPS tether.
Your Honor, the only thing I can express on her behalf is that she does have remorse for missing those dates.
All of them?
Yeah.
And other than that, I discussed with her what her options may be on taking.
My mom, I love my mom, so I have transportation.
She just addressed that she had stable housing through her mother. So that's.
Sentence of the court, $125 statutory fee, 93 days in jail, credit 20. The balance, the defendant is to serve the balance. Thank you.
And there it is, the final ruling in Ashley Pix's case. Judge Simpson sentences her to 93 days in jail, with credit for the time she has already served. Credit time means any days she has already spent in custody are subtracted from the total sentence. In practical terms, this means she will only need to serve the remaining balance of that 93-day sentence. Now, legally speaking, this outcome wasn't entirely unexpected. When a defendant repeatedly fails to appear and ignores court instructions, judges often conclude that probation simply isn't appropriate. Remember, probation relies on trust. If the court doesn't believe someone will report, follow conditions, or show up when required, incarceration becomes the more reliable enforcement option. This sentencing also sends a broader message to other defendants watching similar hearings. Ignoring court orders has consequences, but now the courtroom is about to move into an entirely different case. And this next one brings an even more complicated situation involving probation violations and multiple new criminal charges.
Rhodes.
Teresa Clare on behalf of probation, Your Honor. Mr. Rhodes is scheduled before the court today for a violation of probation hearing. Probation would like to correct the balance owed to the court is $1,055, with the last payment being made to the court on May 8, 2024. Mr. Rhodes has failed to complete the terms ordered by the court in that he did not complete IOP treatment. He failed to provide proof of his AA meeting attendance, failed to attend the victim's impact panel, failed to report to probation as directed. He also failed to appear at 2 prior VOP hearings before this court where bench warrants were issued. In addition to that, Your Honor, Mr. Rhodes has new pending criminal matters. One out of the 34th District Court for domestic violence. Alleged date of offense is May 11th of 2022. That is on bench warrant status. He has 2 cases out of the 14A2 District Court, one being a domestic violence, the other being an attempted R&O. Alleged date of offenses, first being August 4th of 22, the other being November 3rd of 2022. He is scheduled for pretrials in both of those matters. He has another matter out of the 34th District Court for an alleged larceny under 200. That alleged date of offense is November 12th of 2023. He's on bench warrant status in that case. He also has a pending felony, a larceny in a building, alleged date of offense of June 27, 2025. He is scheduled for a PCC in that matter on July 10th. Of 2025. It appears, Your Honor, Mr. Rhodes has continued to pick up criminal cases while on bench warrant status in this case and being in violation of the probation that was ordered by this court. Given all of that, probation is recommending that the court order Mr. Rhodes to serve 93 days in jail with credit for 16 days that he served to date.
Now we're dealing with a very different kind of probation problem. Unlike Ashley's case, which focused primarily on missed appearances, Mr. Rhodes' situation involves something far more serious. New criminal charges while already on probation. In the legal world, that's a major red flag. Probation is meant to be a second chance. The idea is that instead of serving jail time, the defendant follows strict conditions and stays out of further trouble. But when someone commits additional crimes during that probation period, the court often views it as a failure of that opportunity. Listen to the list of allegations the probation officer just described. domestic violence cases, larceny charges, and additional pending matters across multiple courts. Each of those cases adds pressure to the judge's decision. But then the defense attorney introduces something important: context. Mr. Rhodes and his family reportedly experienced homelessness, financial hardship, and were raising 3 young children during this time. And this is where sentencing becomes complicated. Courts have to balance 2 competing ideas: accountability and circumstance. Should the judge focus strictly on the violations, or should the financial hardship and family situation influence the decision? This is exactly where the hearing becomes emotionally complex.
That he serve the balance, that he complete the in-jail on-farm program, waive remaining terms, accepting his financial obligations, and discharging him from probation with them.
Ms. Berman.
Your Honor, I am asking that you sentence Mr. Rhodes to the 16 days serves and close out this case. I did have an opportunity yesterday to speak with Mr. Rhodes for quite some time. I think what his issues really come down to is his finances. He explained to me that he and his family have been homeless all of last year and are just now getting back to a better spot. They were staying at the Red Roof Inn for some time, and then they stayed at shelter for some time. This is all while they had, at this time, they have 3 kids under 3. His partner just had their newest baby in January. And at the time during last year, she was obviously pregnant with 2 children. So they were dealing with some serious financial issues. Mr. Rhodes says he did not have even a phone or a car to get anywhere. He did say that he was enrolled in the MRT program, which he believed was being used, I suppose, in place of his IOP. So he did complete some of the MRT program, but he did not complete it as it does require money to stay in it. He did just do a week. I think he was picked up on the warrant and did pay bond to get out. He said during that time, just a week really affected his partner and their living situation because he could not work. He is enrolled in a job program through the Friend of the Court, so he is working now. He also says he did attend some AA meetings, but because of his situation, he wasn't able to continue to those. I do know that the larceny cases, he is being represented by the public defender's office, and he said there is an offer to reduce that felony case down to a misdemeanor. He's asking that the court take all this into consideration and the struggles that he and his family have been going through. But again, he is in stable housing now and is working.
The case ending in 1357, which is a show cause hearing, I'm going to adjourn that to September 10th, 2025 at 9 a.m. On this other matter, sir, is there anything else you want to tell me other than what your counsel's indicated?
Yes, Your Honor. That's what she said is exactly correct. It was a hard time, and I admit to the violation. I'm trying to get everything situated. I can make a payment today, and on the 12th, I just have to get rent paid before the 15th, and then I can continue to make payments every month until I can get the balance dismissed. Lowered down.
These new cases, not doing it that way. Sentence of the court, 93 days in jail, credit 16 that he served. Defendant is to serve the balance. He's to report to the Washington County Jail by 6 p.m. today. If he fails to report, a bench warrant with no bond will issue. He is while in jail to complete the Dawn Farm in jail program. I will waive all other remaining terms except his financial obligations, discharge him from probation without improvement. Thank you.
Thank you.
And with that, Judge Simpson delivers the final decision in the second case. Mr. Rhodes is sentenced to 93 days in jail, with credit for the 16 days he has already served. He must report to the county jail by 6 p.m. the same day, and if he fails to appear, a bench warrant will be issued immediately with no bond allowed. The judge also orders him to complete the Dawn Farm in-jail rehabilitation program, which focuses on substance abuse recovery and behavioral change. Interestingly, the judge waives most of the remaining probation conditions and instead focuses on financial obligations. That decision suggests the court wants to close out the probation case while still holding him accountable for the violations. When you step back and look at both cases in today's hearing, a common theme emerges: accountability versus opportunity. Ashley Pix asked for probation but had a long history of missing court appearances. Mr. Rhodes argued that financial hardship and family struggles prevented him from completing probation conditions, yet both ultimately received the same core sentence: 93 days in jail. These decisions highlight one of the biggest realities in the justice system. Judges must weigh personal circumstances against patterns of behavior and public safety. Now we want to hear from you. Do you think the judge made the right call in these cases? Should Ashley have received another chance at probation? And should Mr. Rhodes' financial struggles have influenced the final sentence more? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.